Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-argument episode of SCOTUScast, Insanity Defenses and Unanimous Juries Edition. I'm your host, Grace Gotchling. On October 7th, 2019, the Supreme Court heard oral arguments in Kahler v. Kansas and Ramos v. Louisiana, both of which raise questions of constitutional criminal law. In Kahler, a jury convicted James Kahler of capital murder. Among other things, he objected at trial to a Kansas statute limiting any mental disease or defect defense to formation of the requisite mental state for the charged offense. The statute, Kahler argued, denied him due process by depriving him of the ability to present an insanity defense. The Supreme Court of Kansas, following its precedent, noted that state law had deliberately abandoned lack of ability to know right from wrong as a defense, and rejected Kahler's argument. The U.S. Supreme Court subsequently granted cert to consider whether the Eighth and 14th Amendments to the U.S. Constitution permit a state to abolish the insanity defense. In the Ramos case, Evangelisto Ramos was convicted of second-degree murder by the vote of 10 of 12 jurors. Challenging his conviction, Ramos argued that Louisiana's statutory scheme permitting non-unanimous jury verdicts in non-capital felony cases violated his right to equal protection under the 14th Amendment to the U.S. Constitution. Relying on its precedent, the Louisiana Supreme Court rejected Ramos's argument. The U.S. Supreme Court subsequently granted cert to consider whether the 14th Amendment fully incorporates the Sixth Amendment guarantee of a unanimous jury verdict in criminal cases against the states. And now, to discuss the cases, we have Giancarlo Canaparo, legal fellow at the Heritage Foundation.
Kahler versus Kansas is a case, the question presented to the court was whether Kansas can abolish the insanity defense. I'll get into this a little more in detail later, but there's some dispute between the parties about whether what Kansas did was really abolishing the insanity defense or reforming it. Briefly, the lawyers for the case, the petitioner, Kahler, was argued for by Sarah Schrupp of Northwestern University. Respondent, Kansas, was argued for by Toby Krause, the Solicitor General of Kansas, and the Deputy Solicitor General Elizabeth Prelogar also argued on behalf of the Solicitor General's office in favor of Kansas. The facts in Mr. Kahler murdered his ex-wife, two of his children, and his former mother-in-law because of what he and his experts called a psychotic break. At trial in Kansas, he was unable to offer the typical insanity defense because Kansas has said that the evidence of insanity can only be used to disprove mens rea, but the traditional affirmative defense type use of that evidence is no longer permitted. So Kahler was convicted, and he was, after a separate jury proceeding, sentenced to death. He now argues on two grounds that the Kansas rule is unconstitutional. First, on due process grounds. He argues that history shows that a mentally ill person who commits a crime is not morally responsible if he doesn't know that his actions are wrong, and that historical practice is deeply rooted in our constitutional history. As to the Eighth Amendment, he argues that essentially conviction and punishment go hand in hand, and that oral argument expounded on this argument a little further, that conviction carries stigma and collateral consequences, and so it's cruel and unusual to convict somebody with all that subsequently entails if they're mentally ill. Moreover, he argues that punishing an insane person serves no penological interest or justification. Kansas disputes that it abolished the insanity defense, but argues that it redefined it or reframed it by permitting evidence of insanity as to mens rea. As to the due process argument, Kansas argues that Kahler has the history wrong. Before the 19th century, Kansas argues, and the history backs this up to some extent, that insanity focused on criminal intent, not, as Kahler argues now, on knowledge of right versus wrong, and that not right versus wrong distinction appeared with the now famous M'Naghten test out of England. So the Eighth Amendment, Kahler argues in a fairly straightforward textualist basis that the Eighth Amendment prohibits punishment and not conviction. So before I continue, I'll say that I'm not an entirely unbiased party in Kahler versus Kansas. My colleague Paul Larkin and I wrote a law review article on this point in favor of Kansas, but I'll keep my own editorializing to a minimum, and we'll talk about what the justices did at oral argument. So when petitioner got up and began his argument through Ms. Schrupp, Ginsburg fired off the first question almost immediately. And she noted that other countries use a verdict called guilty but mentally ill, which operates to hold somebody guilty through the trial and conviction stage, but says you're mentally ill and so you won't be sentenced to prison, you'll go to a mental institution. And she asked petitioner if that would be unconstitutional. The petitioner said no, that would be unconstitutional because conviction carries collateral consequences. So Ginsburg followed up and said, well, if we remove all collateral consequences and simply put a criminally insane person in a mental hospital after convicting them, would that be okay? And petitioner said no, conviction carries a stigma. So Kagan jumped in at this point and she challenged petitioner's premise that if the history really is as sure as petitioner says it is with respect to this right versus wrong requirement, why should we follow history? She asked essentially, how do we tell which historical practices we should and shouldn't follow, especially in light of changing state and psychological opinions about the best approach to take with this? Because an undercurrent of these oral arguments was that, look, states need to be able to adapt to changing psychological opinions about what is insanity, how do we pin that down, and how does that interact with the moral sort of conviction that a state imposes on somebody when it sentences them to criminal punishments. With the argument shifting to a historical focus, Ginsburg jumped in again and asked if we should take into account the fact that in the old days, being found insane meant confinement in mental hospitals, which were notoriously worse than prisons. How does that bear in? Alito and the Chief were both very concerned with the expansive nature of what can be evidence of insanity. Alito asked, isn't it sufficient to introduce all this evidence of insanity at the punishment phase? Petitioner said that no, that's not sufficient because juries make up their minds before then. But Alito was not convinced. He was definitely the most hostile of the justices to petitioner's argument here. At one point, he actually went through the facts of the case in painstaking detail, really painted Kahler as an unsympathetic guy. Kagan actually seemed to agree with him. She asked, look, in none of the states that have the insanity defense, I'll quote, she said, in none of the 46 states, I'm guessing, would your client be found insane. She asked how often people are really found guilty and how often is this insanity defense really successfully used. Kavanaugh took an interesting position. He seemed to be the only justice who really bought, I think, Kansas's argument that they reframed rather than abolished the insanity defense. I don't think that the answer to that question mattered for a lot of the other justices. On the whole, I think that they were mostly on Kansas's side here, with the notable exception of Sotomayor and Breyer. But Kavanaugh seemed to buy that distinction, and he supported the leading book on the topic of the insanity defense, a book by Goldstein, which argued in large part that states need to have the broad discretion to do just the sort of thing that Kansas has done. Gorsuch and Alito took a really interesting tact here and seemed to recognize that there are broader implications for other kinds of crimes. They both wanted to know what would the effect of a decision in petitioner's favor be on strict liability crimes. If essentially the states have been allowed, as the Supreme Court has done, to abolish the mens rea requirement for crimes entirely and have strict liability crimes, why is what Kansas has done here really any different? Both petitioner and respondent seem to agree that for one reason or another, which wasn't really well articulated, insanity cases are just different. Alito asked a question which I think was kind of the defining moment for petitioner, which was if we went back in time and used the irresistible impulse test, which is an older pre-M'Naghten insanity defense that said if you were motivated by it's a post-M'Naghten insanity defense, which existed sort of briefly and was abandoned. But if you are under an irresistible impulse, you can't control your behavior and you commit a crime, you're insane and you're excused. And he said, if we went back to that test, would that be unconstitutional? And petitioner said yes, because there's no consideration of right and wrong. Personally, I think that was a moment where petitioner shot himself in the foot because it undermines his historical argument, his argument that history has always looked at this right and wrong approach. In truth, the states and other countries have tried a whole broad array of approaches, from the irresistible impulse test to a variety of different tests. And so by admitting that was unconstitutional, although it was historically tried, it sort of undermines her point, I think, that really history has been unequivocal on this. Those justices were largely silent, with the exception of Kagan, when respondent took the stand. Sotomayor and Breyer were very concerned with trying to find what Sotomayor called the irreducible minimum. They wanted to focus on just how much really could the state get rid of in terms of insanity defenses and other criminal defenses. Where really was the limit? What could a state do, and what constitutional requirements are at a minimum necessary? Breyer focused. They were both very concerned with this distinction between someone who knows what they're doing is wrong but has no control versus somebody who doesn't know what they're doing is wrong. So Breyer gave the following hypothetical. He said, what do we do with a person who kills a person who's thinking that it's a dog, and a person who kills a person because the dog told him to? In the first case, under Kansas's approach, he'd be not guilty because he didn't form the mental intent. But under Kansas's approach, the second person would still go to jail. But they're both insane, Breyer said, and so why should we treat them differently? The answer that Kansas and the Solicitor General gave is that, look, these are judgments for the states to make. They get to determine various considerations, be they moral, be they penological, be they based on psychological research, but these are the questions that states get to answer, and we don't want the court to nail down a constitutional rule that prevents states from being flexible here. Kagan didn't seem particularly hostile to Kansas' position, but she was concerned about just how far Kansas could go. She wondered whether Kansas could eliminate moral consideration as sentencing too, whether it could eliminate other defenses. And Gorsuch joined in to ask if Kansas would accept some floor of mens rea inquiry in all cases, to which Kansas said yes. Again, he seemed to be hinting at strict liability cases. And as we know from last term, there was the case of Rehafe versus United States, where the court expressed some skepticism about the extent to which strict liability and a lack of mens rea, that we could have no mens rea requirements in certain cases. Both sides, again, seem to agree that when it came to the comparison to strict liability and regulatory crime cases, they're just different. Insanity cases are just different. When the SG came up, there wasn't a lot of new bases covered, but Kagan seemed, again, to be probing the SG with a way somehow to side with Kansas. It was my sense that she wanted to side with Kansas, but wanted some sort of limiting principle, some sort of sense that they couldn't eliminate anything, all consideration of mens rea, all sort of criminal defenses. Just how far could a state go? It wasn't really clear to me that she got an answer that was satisfactory to her. You know what they say about reading tea leaves and trying to predict the future, but my sense is that Kansas has the winning argument here. I think that Sotomayor and Breyer are solidly on the other opposed. Whether Kagan comes along with them, I don't know. Turning now, we'll move along to Ramos. We'll stop at the end and do questions on both cases together. But Ramos is another criminal case. Until 2018, Louisiana had permitted non-unanimous juries in criminal cases. You could have a jury of 10 voting 10 to convict, 2 to not convict, and 10-2 was fine. You didn't need unanimity. Oregon still has that rule. Louisiana changed it, but only going forward. So in Ramos's case, he was convicted of first-degree murder by a non-unanimous jury just before the law was changed. And so this argument is a Sixth Amendment argument, whether the Sixth Amendment requires unanimity. The briefing is focused a lot on the historical practice, whether unanimity is deeply rooted in our historical practice. But the argument really hinges on a case from 1972 called Apodaca. In Apodaca, the court actually confronted this question. The question was, does the Sixth Amendment in general require unanimity? And then is the Sixth Amendment incorporated against the states? And is that part of the Sixth Amendment? To the extent that the Sixth Amendment requires unanimity, is it fully applied against the states such that they too need to have unanimous juries? And the court split 4-1-4. And that creates that creates a whole host of issues for this case. So 4 justices said, no, it's not, the Sixth Amendment does not require unanimity. 4 said it did, and Justice Powell ended up being the sort of deciding vote here. He said that the Sixth Amendment does require unanimity as to the federal government, but it doesn't require it as to the states. I'd say at least most of oral argument, sort of a small majority of the time, was spent on the stare decisis question here. The justices were very concerned with how do you deal with stare decisis when you've got a 414 case. Although it's 414 and Powell's decision was not joined by anyone else, the rule that Apodaca set out has basically been undisturbed for 50 years. Oregon and Louisiana have a reliance interest. They've structured their criminal justice systems around this. So what do you make of that problem? And they in fact, Alito actually brought up the fact that last term there were several dissents in franchise tax and Nix, where the dissent really went after the majority for sort of what the dissents called sort of throwing stare decisis aside. And so he said, look, we've got very active dissenters last term who really wanted stare decisis to stick. So what do we do with them? How do we distinguish this case from franchise tax and Nix and the reliance interests at stake there? Kagan asked, why can't we just say, look, we give the states a lot of latitude in criminal justice issues. Why can't we just say, okay, look, Apodaca was an anomaly, but we're just going to make an exception here. We're just going to let states do, something else. We're not going to fully incorporate just this part of the Sixth Amendment against the states. A lot of back and forth between Alito and Kagan here on that point. When it came to the Louisiana's argument, the timbre of the court changed. It became very clear, especially as Louisiana's argument went on, that the court was becoming increasingly hostile to Louisiana's position. Ginsburg noted that Apodaca, 5 votes said that unanimity is required for the federal government, and asked, are you asking us to reverse that position? Kagan sort of piled on and said, are you asking us basically to start from scratch and just treat Apodaca as, an anomaly? We're going to start from scratch, answer the Sixth Amendment question from scratch, pretend none of this happened. There was a problem for Louisiana in that the lawyer couldn't give a good sense of what she really wanted. Did she want to rely on Powell's opinion in Apodaca? Did she want the court to start from scratch? Kagan really hit the nail on the head with this confusion in this issue, and she said to Louisiana's counsel, you don't really want us to take this issue fresh, do you? Which sort of caught her off guard. And she said, look, your brief says that Powell's opinion is not precedential, but your argument is based in large part on this reliance interest that you've got, that you and the state of Oregon have. But you don't have that reliance interest. Doesn't make any sense if you're not going to rely on Powell's opinion as precedential. So there was a lot of confusion going back and forth there. Gorsuch jumped in to ask, let's turn our focus to the Seventh Amendment. There's an old case on the book. The name. He gave the name, I didn't catch it, but there's an old case that he said is more than 100 years old that said the Supreme Court says that the Seventh Amendment requires unanimity for civil jury trials. So why should there be any difference for criminal trials? Louisiana really couldn't give a good answer on that one. The Chief Justice asked, how far would you be willing to depart from unanimity? Is 7-5 okay? And then Alito asked, what about when does it start cutting the other way? When would you rather have, say, a 6-0 opinion versus a 20-1 opinion? What if petite juries were the same size as grand juries? And then I think that Sotomayor really had one of the best questions, and for Louisiana, one of the toughest questions. If she asked, if you have this parade of horribles if you lose, suddenly you've got 36,000 cases where there might have been a split jury, and you've got the criminal justice system is going to be overburdened trying to process these cases, and everyone's going to be filing for new trials and habeas petitions. But what about this parade of horribles if you win? If Louisiana can get rid of the unanimity requirement, can they also get rid of the guilty beyond a reasonable doubt requirement? Could they also get rid of the requirement that a jury be a representative cross-section of the community? Where these things aren't in the text of the due process clause, which was really the heart of Louisiana's argument. So she said, where's that line? What can we get rid of, and what can you not get rid of? The other really great question, I think, came from Justice Gorsuch, and he said, look, you've got this reliance interest. Okay, I take that. But what about the people in jail? Gorsuch seemed to accept that it seemed that he was on board with the idea that the Sixth Amendment required unanimity. And so he said, look, if that's true, that unanimity is required by the Sixth Amendment and it's fully incorporated against the states, is your reliance interest sufficient to overrule this constitutional wrong that was imposed on all these people in prison? Isn't the Constitution a document that should endure, so we should get it right? Kavanaugh joined him and said, look, assuming that he's right, people have been convicted unfairly, and that the history shows that Louisiana's law was motivated in no small part by racial animus against black people on juries, why aren't those concerns enough to overrule your reliance interests? The answer, I'll give you the answer that respondent gave. It was not, I didn't really follow why this made sense, but the answer was that it's not unfair that these people went to prison because 6 jurors is okay. So this was a somewhat confusing thread during the oral argument that Louisiana said, look, you've said, the Supreme Court, that 6 jurors is okay. So if 6 jurors is okay, surely 10 jurors is okay with 2 dissenters. Now, in rebuttal, the respondent said, and this will be the last point before we open up to questions. In rebuttal, the petitioner said, this 10-2-6-0 distinction, that's not a real, it matters because it's more, we can be sure that a jury is unbiased, delivering a good, solid conviction when you have unanimity. Alito didn't seem to buy it, but in response to his, I'm not sure that that's correct, that speculation argument, the petitioner brought up a better argument, I think, which was that the purpose of the Sixth Amendment is to enshrine a representative cross-sample of the community and to prevent racial discrimination within the jury so that you could essentially ice out part of the community. So consider a jury of 12 people, 2 of whom were black, 10 of whom were white. If a unanimity is not required, you can exclude those 2 black people from effectively participating in the conviction. That, I think, was probably petitioner's strongest argument of the day. One last point before I open up to questions. The petitioner finished up his rebuttal by returning to this point about stare decisis and what do we do with Apodaca. And he made what I thought was a really good argument. And he said, look, Apodaca, it's actually sort of, if you were to essentially reverse Apodaca, what you're not actually doing is reversing precedent here. You're actually, by getting rid of Apodaca, settling law that's already been around forever. Because before Apodaca and its 414 decision introduced all this confusion into the law, you had opinions that said the Sixth Circuit requires unanimity. And you had opinions that said when we incorporate, it's full incorporation. So if you reversed Powell's opinion in Apodaca, what you're doing really is simply enshrining those 2 principles and saying, look, this is what we've held in different cases, disparate cases over time. We're just going to re-enshrine it here. If you really actually affirmed Powell and Apodaca, what you'd be doing is unsettling the law, allowing states to sort of open Pandora's box, as Justice Kagan and Justice Sotomayor sort of hinted at when they were probing for limiting principles. Suddenly the law is unsettled. Where is the limiting principle? So this case, when the question is do we overrule Apodaca, it's an unusual precedential decision or unusual sort of stare decisis concern because it's not. It's sort of stare decisis in reverse. You're reversing, yes, but you're not. But you would actually be unsettling the law rather than settling the law.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.